So thanks everybody for being here. As I mentioned, so I'll introduce myself briefly, and then I'll open it up with kind of our first question. I'll give just a brief introduction to the topic, though. I know some of the language that I used in the emails, I had people write back and say, that's not the language that we use. So I just want to make sure everybody's on the same page about what we're discussing. But again, I'll do an introduction first. I'm Stephen Goldmeyer. I use he, him pronouns. I live in Columbus, Ohio. I worked at the State Public Defender's Office here in Ohio for a bunch of years. Then I worked at the Bronx Defenders, and now I work on a research project with Southern Methodist University. And I would also like to shout them out as hosting this event for today. We use their Zoom account. They host us and take care of some of the logistics. So I really appreciate that. But the project I'm working on is actually researching upstate New York. So I'm familiar with Ohio and New York in as far as doing research in public defense systems, as well as, here and there throughout the rest of the country. So I thought it'd be helpful for me to give that introduction. The topic for today is one that I think we as the IDRA board and in different contexts throughout our time as IDRA have sort of hinted at. There seems to be a difference when you're conducting research and when you're trying to do these kinds of projects, and even when you're implementing things based off of research, there seems to be a difference in how you're able to do that and what challenges you'll have, whether you're working within a system where I've heard them called home rule states where counties get to make their own call about how they're going to provide indigent defense services and then seek reimbursement or other kinds of setups like that, versus statewide systems where a statewide organization runs offices throughout the state and really controls what happens with indigent defense funding. There are some pluses and some minuses when you're trying to do research in each of those contexts. And one of the things that's special about IDRA is that there are people from all over the country in a bunch of different states. So we thought it'd be good to bring people together to talk about what the varieties are in how these systems work and what impact they have on research. So the opening question that I sort of thought about and thought would make sense to start things off is, what kind of jurisdiction are you in if you think that your jurisdiction is indicative, a good example of one of these kinds of situations, and like how does this play out within your jurisdiction? So anybody who wants to get us started, I did, as I say, seed a couple of folks to say, can you show up and maybe talk a little? So maybe if those folks want to start us off. Torrin, I see you're unmuted.
Yeah, I'm happy to start. So
yeah, please.
In addition to being an IDRA board member, I am the research and statistics analyst for the Indiana Public Defender Commission. So I primarily know about Indiana exclusively, although, I've had some exposure to other states just from talking with you all mostly. But Indiana, I think, is an extreme example of a home rule state. I could be wrong, and maybe I'll find out in this discussion, but where counties can decide to do whatever they want. The state will pay them an amount of money. It's 40%, but there's some, not all case types and stuff. So it's a little less than 40% in exchange for following state rules. Even following those state rules, they have a ton of freedom on how they provide those services. There's just some rules that they have to follow, and it has to be, one of a series of options that are available. And so, yeah, that I think I can definitely speak to the primarily disadvantages, but maybe some advantages of that as a research environment where we have wildly disparate systems, and also we primarily do not have information about a third of the counties because they don't take part in our system, and so they do not send us data. So I think that's a good enough background for now.
Yeah, I appreciate it, Torrin. I will say that you hear this. I think they call it the Indiana model sometimes.
Yeah,
yeah.
it is often called the Indiana model, although as I understand it, Ohio actually had it first. So
yeah, I was about to say
we got stuck with that, but
because I know that Ohio is very similar. I think that there's been some really valiant efforts by the State Public Defender's Office, both in Indiana and in Ohio, about trying to standardize data collection and reporting, and really create some accountability on what's actually happening and getting data back, really getting some data in exchange for that funding, which I know that isn't, you don't have to make that same valiant effort when it's a statewide system. So, but yeah, Dean, I saw you unmuted a moment ago.
Well, I will say I don't know if the Ohio model is a positive or a derogatory term, but I will tell you that it's worse in Pennsylvania than that. It is all run by the counties, each individual county. Their board of commissioners or whatever their ruling body is appoints the public defender. And there is absolutely no funding from the state for indigent defense in Pennsylvania. I mean, and so, the money that goes in from Philadelphia and Pittsburgh may be completely different than the small rural county. And just the way public defense is done. I know that in one county, someone told me that the probation department appoints the public defender to the case. So there is no statewide overview of the public defender's office. No money, no rules. We have a Defender Act, and it's pretty basic. So, in terms of data, everybody has to go and decide what they want to do. So, when in Montgomery County, we had a data system that really wasn't working. We tried to get Legal Server. The county decided they wanted to build their own. So we built our own. And we can talk about why they wanted to do that. So everybody does it differently in Pennsylvania, and Philadelphia, has a great collection system, but they've got millions of dollars to do that. And so in more rural counties, they're using, something off the shelf usually.
Yeah, the zero funding from the state, that sounds pretty challenging. Although I know that the problems are very parallel between, I guess, the three systems we've talked about so far, which is that the counties are disparate in funding and decision making, and therefore are making their own road on data collection and things like that. This happens to be also the way it works in New York. I know there's a unified court system in New York, which creates some benefits from maybe unified terminology, unified process, a little bit here and there, but the counties themselves still are making a lot of those decisions, which means that, data sets just look different in each county. So I don't know if anybody has any observations from maybe statewide systems or anything that's a little different from what we've described, any of our other attendees today. I've not had the pleasure of working with any statewide systems really when I've done any sort of data or research projects of any kind. I don't know if anybody also has any thoughts, statistics. Oh, Bob, it looks like you're going to be able to share with us now.
Hi, Bob Berukowitz from Seattle. Working with the Sixth Amendment Center and David Carroll and his team, we've done evaluations in state programs, some of which have had good data, and it makes it easier to work that way. Utah and New Hampshire had pretty good data for us to use, Utah in particular. So, and you can read that report online. The New Hampshire report's coming out soon. We've also worked in states without statewide systems, including Mississippi, and there it's much harder to collect the data.
Yeah, I appreciate that. Anybody else have any observations about their own jurisdictions? And if not, happy to hear if people have found that there are, I think it's a little, we're hinted at already one of the big drawbacks when you have these sort of home rule, everybody makes their own decisions kind of systems, which is it's just hard to get data, and it's hard for it to be consistent in any way that's easy to analyze. I don't know if anybody can talk about positives to the home rule type setup. I can mention one to get us started. It's not a major positive, but I found a positive in the research project we're working on now, which is that you can get very close relationships with the county public defenders and their staff. They're really the arbiters of what's going on. So once you sort of get the permission of, yes, we'll work with you on this, the offices are very willing to just do what, like, yeah, so-and-so said it was good, so let's just do it. Here's the data, come sit in our conference room for 2 weeks and look at our files. It has been easier to get that kind of relationship going but I imagine it would just be very different and maybe easy in its own way if we had a relationship going with the state office, right? Then they just sort of send someone down to local jurisdictions. But that's something that I found is the relationship building. It's challenging to figure out who, go to all the different counties and build different relationships with each one. But being local and having specific people in each office has led to really strong relationships that has made some counties very easy to do what we need to do as far as data collection and sharing results with them goes. I don't know if anybody else has any thoughts on pluses and minuses to these different systems. Yeah, Christopher Sadler. Yeah.
Hi, my name is Christopher Sadler. I am in North Carolina.
We can't
Chris,
really hear you, Chris.
Yeah, you're very quiet, Chris. Sorry.
Are you able to hear me now?
It's a little better. Yeah.
A little better. I think this might be the best I can do. I'll just
Should be
speak
good.
a little louder.
Yeah, thanks.
So currently in North Carolina, was in Michigan. And Michigan, we had the Michigan Indigent Defense Commission that oversaw, just a shorthand, oversaw the indigent defense for adult criminal indigent defense, but each system operated separately. And there certainly are some pros and cons to that. The theory being that government and organizations work the best when they're closest to the people. So therefore, those indigent defense systems should mold themselves around the need of the population, which sometimes is the case, other times not so much. What it did allow for, or that sort of setup does allow for, is testing or analysis of a comparison of delivery models. Not just, not talking just flat fee or an assigned counsel system or an hourly system, but also we're talking about variations within those systems. What is a flat fee in Michigan could be any number of things. A flat fee here in North Carolina is pretty much the same thing from county to county that has those things. Same with public defender office. Here in North Carolina, a public defender office typically means the same thing. Rather in Michigan, some of the things that are public defender offices, I don't necessarily think we would strictly, prior to coming in, I don't know if I necessarily would have called some of them public defender offices. So yeah, I do see some pros and cons. And I also do want to say that in statewide systems, maybe data collection is a little bit easier, but it's still a bloody bear in terms of, let's be real, in state government, there's a lot of different systems, a lot of different organizations collecting a lot of different data. So a unified system would be great where you could just go in and grab whatever you want, but it really still is jumping through hoops and managing relationships with different people. That has been my experience. So I think what you give up when you go to a statewide system, or rather not give up, I think you're just changing how you build the relationships, how you collect the data, but certainly pros and cons. And I think that's just part of the whole public administration thing is you have to mold yourself to the environment in which you're working and doing research. So thank you.
Yeah, I really appreciate that observation that differences across counties can also lead to research opportunities about differences in delivery mechanisms, right? And it can be such strange things, like do they qualify them at the jail or do they qualify them in the court, right? And you're not going to maybe have that difference as much when it's a really standardized kind of process. So even you could find weirder research opportunities maybe in those home rule contexts. Yeah, Paul, I see you turned your video on. I don't know if you had something to contribute or.
I did, but Katrine actually raised her hand, so I'll let her go first.
I'm sorry, I missed that.
Yeah. No, no worries.
Yeah, please.
Hi, good morning, everybody. I'm here. I'm from the state of Washington. I think probably a third of the people in the room here are from Washington as well. We would be one of those home rule states, not too different from what you've already described. One of the questions I have for everybody in the room is, of course, data collection is a huge challenge for us. We collect some information at the state level with the little bit of money that we give out. It only amounts to about 4% statewide of public defense, but that's how the incentive to get some information, but it's not real data for study level. In our court system, the court management systems that are used do not track the appointment of counsel. And so even working with the courts, we're not able to use their data on that level, which would be one great way to try to figure out, to do some type of research using court data. But there is no distinguishing factor like that, either for our courts of limited jurisdiction or general jurisdiction. I'm wondering if anybody in the room here has gone through that issue and maybe has figured out a solution on how to convince your court system, which also is not unified, on how to distinguish public defense cases for data collection purposes.
I actually would love to talk about that just slightly, and then I'll kind of segue into what I was going to say, which actually is kind of perfect for it too, which is first, I would be so I am not a researcher by background, but just work a lot in research. But I come more from the public defense side, and I would tell you that public defense is probably less likely to participate in research studies that are semi-hosted by the courts, because there's such a feeling of confidentiality that's so important to attorneys. I'm not one of them, the attorneys, but I just know after being with them for 20 years that it's something that I would strongly encourage actually having somewhere else. Now it's hard to do because a lot of courts still have case assignments being done by the courts themselves. So that's kind of difficult, but if that in itself, I would strongly encourage you, if you have courts still overseeing assignments and payments, get NLADA or NAPD to help you get some really good policy decisions to get that out of there, because that is probably like the worst thing in the history of indigent defense is having the courts involved. But I guess I would say that you could also look at in Arizona, there's a statute that requires case loads to be reported annually. And it's just general caseload by felonies for the public defenders. And I think one thing that's interesting is a lot of states sort of created that thinking, well, it'll be the public defender's office, and didn't really think about contract counsel. And we try to make sure to actually include both in there in our reports, because we actually feel that it's important for the state to recognize that we really do have multiple types of assignments. So I would say maybe looking at that realm a little bit. Yeah.
I think maybe I misstated something. I just want to clarify, because we got some good things here. All I'm talking about is for data collection purposes. Actually, here in Washington, I'm really happy to say our Supreme Court just passed a rule that goes into effect January 1st that prohibits judges and court administrators from overseeing public defense, which is fabulous. It's going to cause a lot of waves here. And also, we do have mandatory caseload limits. Where I'm interested in from a data collection perspective is like trial practice and motion practice, or even case assignments, or the types of cases. I think there's so much court data that could be helpful for us to explore what are the types of cases, the loads of cases, the practice, and we can get that data, but there's no distinguishing factor between public defense, private, or even pro se. And so that what we would love is if our courts could actually identify that this was an appointed counsel case within their court management system, since we have a non-unified system and can't require that of defense attorneys statewide. Does that make sense?
It does, and I think probably Torrin and Celia have some comments too. I guess I would just still, pro se is obviously something the courts probably should know about, but I almost just wonder if it's almost a problem to try to put that on the courts as opposed to trying to figure out another way to do it. And the only reason I say that is because then somewhere the courts are still recognizing that this is an appointed case, an indigent case versus a privately retained case. And I think almost from an equity standpoint, I really just want the courts to have that out of sight, out of mind type of mentality of this is just a lawyer and a client. And anyway, so that's just my feeling, but I think I'm going to hand it over and I'll come back to my other comment later, because I think Torrin and Celia might add to that.
Yeah, I'll say in Indiana, our court management system is not unified, but it is unifying. It's a pretty significant number of counties that are at least mostly on the same court management system, and they do use that to collect data, and it does collect information about indigent appointments, but there's a ton of problems with it. There's very low motivation on the part of the people that are actually in charge of entering that data to enter it accurately, and to enter it in a timely fashion. So for indigent defense stuff, the Supreme Court does release yearly reports about caseloads and about costs, but they come to us and talk to us and ask questions to us, even though we don't have data for 20 something of the 92 counties, because we have both a direct relationship and an auditing process for the data that we receive, and we also have the carrot to do it accurately. We can't be perfect, because we aren't actually going in there and making sure they're entering the numbers correctly, but we have a pretty robust auditing process that we do quarterly. And so even though the court does have a fairly unified system at this point, their data is not very good. It comes super late. Like, generally, we don't get those yearly reports until the end of the following year. So we'll be getting the 2021 reports, in November to December of this year. Whereas we're done on a 3-month lag. So, and then again, also it's super inaccurate in terms of like what an appointment is, how many appointments there are, what attorneys are working as PDs versus working as private attorneys. We actually did we paid for a much more detailed data pool, and we ended up having to throw away most of it. I see a question. Yeah, Indiana is moving to Odyssey, and yeah, so we did a paid for data pool, and we had to essentially throw it all out because we found out that if there was a case of e-file, that data could not be reliable. Like, it basically, if there was an e-file, then that information would count them as not a PD, even if they were one. So we saw this huge trend where there were a very quickly reducing number of PD appointments. And when we talked to them about it, they're like, oh, that's because e-file started increasing, and we're just not counting those, apparently. So I would echo, for, I think, totally different reasons what Paul is saying, that I just don't think the court is a great place for it unless there's really good infrastructure to, basically, I think the PDs have to be involved in the development of that software and the way that data is collected. And without that, you're not going to get the data that you want. And I also think there needs to be a motivational component in terms of, like, there needs to be a reason for those courts to accurately report that data. And if they don't do it, then something happens to them. Either they lose money or they gain money if they do it correctly, one or the other.
So, Celia, I'd like you to go next, but I also want to just note that in the chat, we have some talk about data bills and ways that bills could maybe be written to make data collection a little more, more explicit language maybe in those bills. I'd love to hear more about that, but I do want to turn to the folks who have their hands up first. So hold that thought, Maria and Chris, and we'll come back to it. Go ahead, Celia. Thanks.
Hi, my name is Celia Joyce. I'm at New York County Defender Services. We are an agency in Manhattan, and we're not public defense in the traditional sense. We're technically like a private agency that takes indigent clients. So we share caseloads with legal aid and neighborhood defender services, which are specific to Harlem. But most of our funding comes from a contract from the city, Mayor's Office of Criminal Justice, and then also a contract with Indigent Legal Services, which is a statewide organization that came to be as a result of a lawsuit that showed that indigent legal providers weren't able to provide the same caliber of support because of like high caseloads. And so I think everyone in the state receives, who provide defense for indigent clients, receives some funding from them. And so I guess in that sense, there is sort of a standardized set of data points that we have to submit to them. But the way that they classify things, like what type of case something is different from our other contract. And so we have to keep track of like multiple different classifications within that. And then there's also, so yeah, there's technically the unified court system, but it is challenging to get the data. It's not consistent. There's the Office of Court Administration put out has some like data sheets, has some open data stuff that you can access. But when we went to take a look at it, we realized that it was incredibly flawed. Like they were missing a lot of information. Their race data was wild, which is something that we would want to look at, especially because it is really relevant to our clients. They had for like an entire year reported like 3 Asian people who were arraigned, which is impossible. There's just no way. And so we saw that and we're like, well, how much of this can we even use at all? And so even though we do technically have a standardized court system, it's really challenging to get that. And when it comes to like individual data collection, that is really happening on an organizational basis. And so even within New York City, we see totally different ways of classifying things. And so, yeah, any kind of analysis would really require intense cooperation with other organizations to figure out how we can reconcile our different ways of collecting things. So even though we technically do have that statewide sort of system, it really doesn't play out like that when you actually look more closely at it.
I really appreciate that. So working now in researching in New York State, I can echo a lot of what you're saying. And also having worked at the Bronx Defenders, there is this extra complexity of data reporting for the grants versus the city contract versus ILS. So you're 100% right. It takes a really smart data minds, which I know a lot of offices have, to really make sure that there's like a way of translating all those things to how you want them to be. It's really complex stuff. Absolutely. Next on the list was Dean, then Andy.
So I think I'm answering, I'm going to Paul's question, and so I may have get off the topic a little, but in Montgomery County, it was never consistent. So sometimes they would indicate it was a public defender. Other times they would just put the attorney's name in there. And if the attorney, we had contract attorneys for a while, so they had their own private cases and they wouldn't distinguish that. So we were trying to find out who, what the percentage of cases in the system became vastly frustrating. I mean, you'd have, and so I never could get it consistent, which I always thought was somewhat intentional, to be honest with you, because every time you'd even ask just to change it a little bit, they really wouldn't do it. Now it was a statewide, I think that data piece was statewide, but the county actually inputted it. So I thought they could input the information a little more correctly, but they didn't want to change that. But I could see your point about not wanting to identify as a public defender, but then you can never find out how many cases and how we could analyze the data in the county system, which was really frustrating.
Yeah, I appreciate that perspective. Andy, and then we'll go to Paul, then Melissa.
Thanks, Stephen. I'm not going to speak it too long because actually I wanted to speak a little bit about what I remembered from New York, and I see Melissa's going to speak also, and she's in a much better position to do it. But what I specifically wanted to say was that I'm really glad that this conversation is focused specifically on data and research issues, and I don't want to expand it too much, but also clearly this state-local thing is a much bigger conversation in defense in terms of how it relates to political control and reform prospects and stuff like that. There's a relevant lesson by merging the two, I think, which is that when we talk about increasing the requirement on places to produce high quality data, or to produce more kinds of data, whether it be the courts or the defenders, I think that in a quote unquote home rule situation, you have to recognize that the political discussion here is about unfunded mandates. The political discussion is about the state requiring counties to do something. Counties don't want to do it, so they refuse to participate. And that discussion is the discussion that's had around improving public defense services, but it's the same discussion about data. It's the same discussion. And so if states want to make bills to create more data, they have to recognize that that is an unfunded mandate. And they have to recognize that if they are serious about it, what they need to do is not only pass bills, but invest in data infrastructure. They have to recognize that if they're going to put money out there and try and incentivize people to create better public defense services, what they also have to do is put a portion of that money out there and invest it specifically in creating better data infrastructure, because these problems of we don't have the information, our information is irreconcilable, there is information out there, but it's imperfect, are soluble, but only with investment of resources. And so one thing I wanted to tee up Melissa to talk about was the fact that in New York, there is resources from the state going to county governments to actually improve data infrastructure. And I think that that's, if you're in one of these federated systems, and assuming you're not going to statewide consolidated, running everything from the middle situation, that's a potential solution.
So if you don't mind, Paul, I'm going to skip directly to Melissa for a direct response to this. And also, there are echoes in my head of like when ILS had all this extra data collection, they were like, we're also installing these data liaisons, right? And all this infrastructure. So yeah, Melissa, if you can talk more about
Thank
all
you.
of that
Yes,
stuff.
Andy, you're right. It is. We just had a very interesting week here at ILS where in the same day, I was able to have a conversation with one of our data officers who's really embraced, we call them data officers. And ILS provided funding so that each of the counties could have a data officer within the county. And so I had a very interesting day on Wednesday when in the morning we had a great conversation with a data officer who's doing a lot to do data verification in the various provider offices and making sure that the data that they're collecting and reporting to ILS comports with our ILS case definitions and our caseload categories. On the other end of the spectrum, I had a difficult conversation with a provider office who did see this, even with the funding, as an unfunded mandate. And we don't have the staff, and even with a data officer, we still can't do it. And you're asking so many questions. And we also, Andy, as you know, we also have, because we have this home rule system, they're also deciding what case management system they want to use on a county by county or program by program, provider office by provider office basis. So we've encountered a number of different issues when they're working with different databases, the largest of which that's used was never intended to collect data for the purposes of reporting statistics. It was truly a case management system to kind of see where the attorneys were. So when we're trying to overlay things like, did you use an investigator and did you have an expert? Did you file motions? All of these different things. The system wasn't necessarily built to do that. And so we've had to do a lot of work with the vendors for the case management systems to kind of get to the place where we know the system is capable of doing what we want it to do. But then the other part is there has to be ongoing training. As there's turnover in the agencies among their data entry or administrative staff, new people have to come in. As new attorneys come on board, they have to be trained up in all the forms that they have to fill out or on the data entry process if they're able to complete their own vouchers and e-file the vouchers. So even with what we've been trying to do, we're still encountering some difficulties. Is it better than it was? I absolutely think so. Are we where we'd like to be? Not yet.
I really appreciate that. I put my hand up. I'll go after you, Paul.
No worries. I actually think Melissa brings up a really great point. So we in Arizona, we're really kind of a home rule, but one thing that we have, I don't know that all the states have, and I'd really love to know in the chat if people know of these as well, but each county has their own public defender. Contract lawyers are generally ran by a contract office outside of the courts entirely. There's a couple of really small counties that it's still in the courts, but there's also a statewide public defender association that is not, it's a 501c3. We actually created it originally to have an affordable conference every year because we had some training budget issues. And so we just created a conference together. And as a part of it, we've joined together. And years ago, we all went with over a course of a period of time, we all ended up with the same case management system, and we really started talking about how to have sort of a data dictionary. It didn't quite work out to the levels that I would have appreciated, but that system actually was JustWare, and it's gone away. It was hosted by Journal Technologies. It was originally hosted by Newton Technologies, but got bought out. And unfortunately, so now we're kind of all separating, but fortunately, I kept the 3 larger counties. I think we're all going with the same system. I think the one interesting thing that Melissa brings up that NLADA tried to do years ago, and I actually think that they would be willing to do it again, and this group could probably help in this process. They actually tried to do a survey of what types of databases are people using, what systems. And I actually think that there's a huge amount of value that public defenders don't know they have in as customers joining together. It's one of the things that we've really been able to do in Arizona. We did with Journal Technologies, join together as customers and say, we need the ability to do this, we need the ability to do that. And I'm starting to do it with our new vendor as well. But I actually really would be glad to sort of help coordinate working with NLADA if there are people on here who's interested, because I actually think a lot of you have relationships with public defenders who are not very good at reading their emails because they have so many other things going on and they're overworked and have too many clients to deal with the survey. But I actually think there'd be a huge amount of value in just knowing what are the 4 or 5 systems, and is there a way that you could do that? We just wrote a juvenile delinquency survey statewide grant for all the public defenders in the entire state of Arizona to do a study on just our juvenile delinquents and the effectiveness of the counsel for them. We haven't gotten it yet. We're hoping we get it. But I think one of the benefits that we had was what we know that all of our old systems were the same, and that we probably have the ability to merge the data in some way. So I actually think Melissa's point is a really good one. And I really encourage, if there are states out there that have these associations, please, I think we should all know about them so that we have them. Arizona's got one, and we have a board of directors. But I also will just commit right now that I'm glad to talk to NLADA about doing that, because I definitely think it's valuable and we should do it again. And I think that the Research Association would be really great in helping push public defenders to filling it out, or even saying, look, I'll fill it out for you, just answer these 4 questions. Anyway, so I just wanted to say that.
Yeah, I appreciate that. So I actually like raised my hand because I think I have something to contribute on this one. My primary work for years was in case management systems. So working at the State Public Defender's Office here in Ohio, I was one of the architects of our OPD online system. And then when I was working through just another technology consulting firm, and now as an independent contractor, I interact with a lot of different case management systems. So the reason I bring up those 2 examples is I think they're both illustrative of ways of trying to solve this problem, but the challenges that are associated with them. So for the Ohio solution, basically, I'm not there anymore, so I'm not speaking on behalf of OPD, but I can speak on my experience that the goals at the time, the goal was to create a case management system that was just so good and so tailored to like the kind of reporting and work that you have to do for the state of Ohio and for your own work, that you just want to use our system. And that put a lot of pressure on making it good. And I'm happy to say I think we really succeeded. And I think that system's still being rolled out to new counties, all the time by the state of Ohio. The result is that a lot of reporting is done directly through that system. You don't have to do paper reports anymore as long as you use our system or whatever, right? That I think was really a stroke of genius by the State Public Defender's Office and Tim Young here in Ohio to really try to create the right incentive structure for people to use that system. I will say that, so in New York, and really just working in primarily the legal aid context, I saw a lot of legal server users. And so one observation I would make based off of my experience about something like legal server is it can seem like a benefit when everybody's moving towards the same system. Everybody starts using legal server, whatever. But one of the things that makes legal server so powerful is how customizable it is. And so without some real guidance on how to structure your data set and how to think about, I've written the same memo for like 5 different jurisdictions on what is a case. How do you know it's a case versus like 2 cases versus a sub case versus a related case? I've written that memo for like 5 different jurisdictions because that core question changes your whole data set and can actually change the way you collect the data to make it almost unusable in the context of the other data. And depending on how you answer that question, you can customize your case management system off the shelf even if you're all using the same one, to do this in totally different ways. So I do agree that moving towards the same system is a really good idea, but I think agreement on data dictionary and data structure is like really the core of this. And that's why the first step whenever I'm working with folks is we write up, okay, what is the actual structure of your data? I don't even need to see your case management system. Just tell me how you think about your data, and getting that straight, I think is really, really helpful. So I saw that next was Christopher Sadler. Chris, you're next, and then Melissa, then Maria.
I just want to be a little more explicit about what I think Paul and Stephen touched on. The folks, the attorneys working in indigent defense, I mean, that's their job of working for the client. And I think as researchers, we want to help improve the work they do, and we also want to improve the system and outcomes for clients and everything about that. Some of the things I've been guilty on, especially early in my career, is I love data. I love everything about it and the analysis process, and I want all the data in the entire world. And I've been guilty of just burdening people with data requests or collecting too much, that it really starts to strip away. They then have to make a decision about between the client and what I want. And that is absolutely probably the worst thing. So whatever system or whatever is in place, whether it's a home rule or whether it's statewide, I mean, whatever is being done, I think it's important that it's extraordinarily user-friendly and efficient. And the attorneys or whoever is putting in, I mean, I'm mainly focusing on attorneys because their work is with clients. It's not to work for us. That whatever system they have to use and whatever data points they have to collect are very easy. And I think that also leads into when we request data or whatever we're doing, it's really important that we're cognizant of whatever we're measuring. We can have an effect on. We can change behaviors just through that. And part of it was mentioned earlier about issues with demographic information in court data. I have my own speculation about that based on some data that I've seen. And once there was more research being done about disproportionality in courts and stuff, I did notice that there were some modifications in how race data was collected. And I mean, I'm trying to tiptoe around that because I really don't want to put any ill will on anybody, but I do think that illustrates some of the problem with data collection. If we start prioritizing data collection around the fees or something like that, that's where the time and effort is going to go. And also some bad actors can throw it off. So I do think we have to be very conscious of the data we collect and how we collect it going forward. Thank you.
I really appreciate the insight of office sort of just like needing to get the work done, and some other maybe even political concerns are just going to interact with when you ask people to do data collection, and like what is going to help me do my work. It's like maybe the first question any attorney is going to be asking. Certainly, I think that's a really important insight. To Melissa and then Maria.
So yeah, a number of things I wanted to touch on that some of the previous participants have mentioned. One of the things that we're trying to do more of, we have the data officers who are out in the counties, but we also have a data outreach officer here and a data scientist here in the office. And so they've tried to do a lot of outreach to do with each of the data officers and to visit them and to talk about and get a better sense of how the information that happens in the court is captured in their case management system. Again, another way to try to work on data verification and make sure you're doing things right, or the way we want them to be done. I don't know that it's always right, but that's what we need. But in that conversation, we also do some of what you're saying. We try to see how could this data that we're asking you to collect for our purposes also benefit you. And additionally, what things would you like to know as the data officer and both as the chief defender that we might be able to extract from this, or we can help you build a couple additional data points within your own system to tell you things about your own practice. And it really requires that they have someone in their office who is very skilled in not just the data entry, but the data extraction. And so we also try to, when we know each year, we include in one of our reporting requirements a question as to what case management system is being used, so that we can put people in contact with each other. Legal Server has come on the scene, and we do have a couple who are using that now. And so we try to keep those data officers in contact with each other. But one of the other things we did about the case management system is we decided we had not only money for the data officer, but each of the provider offices had a budget where if they wanted to update or implement a case management system, ILS provided funding for that. And so instead of having to answer the same question over and over, we did a survey of the vendors who we knew were currently providing case management systems in New York, and we asked them a series of questions. And we collated that data, we sent it back to the vendors to make sure that we had accurately captured what they had told us. And then we made that available to our chiefs and our data officers to help them assess what, we don't take a stand on which CMS is better, but we know the needs of assigned counsel programs are different than those of institutional providers. We know the needs of provider offices who only provide criminal court representation are different than those that do both criminal court and family court representation. So we just wanted to provide the same information for everybody to kind of assess where they were. And so, and the other thing that helped us to do once we have the information, it's very difficult. I hear you when you say you have the same memo you're writing. How are you defining a case? Fortunately, we do have case definitions, but it's also difficult when you're having to have the same conversation when you know they have the same vendor. So we've tried to do more work with the vendors so that they're clear on what our data reporting requirements are. The vendors are invited to come to our data officer trainings that we have on different aspects of our data collection. And then they're welcome to call any of us, the research team that do the work on these different sets of data that we collect, to ask specific questions. So we always update our FAQs. And so you really do have to do a lot of work in a quote home rule state to try to keep everybody on the same track. So those are all the things that we are trying to do that.
I really appreciate that. I will say there's a part of my brain that is very skeptical of conversations that include vendors as well as their clients, right? Sort of outsourcing some of this to vendors, but in practice, you just have to do that, right? You just
exactly. Exactly. And we did it the other way around. We found ourselves, and the reason we kind of tried to remove ourselves is we were in the middle of vendors and our provider offices, and that wasn't a good place to be either. So this is where we are. This is where we're trying to be at now.
Yeah, it's a challenge.
It is.
Maria, please go ahead.
Okay, can you hear me now?
Yes.
Okay,
yes.
Yes, okay. So, I'm a huge proponent for as much data as we can get, because I always want to know like what's going on with the nuances of how do we decide what we're doing and if it's effective. But so I think all defenders need to be tracking data. But I think that you always have to step back and have that context data, and that can be really hard to get. So I just wanted to share with it in Mississippi in 2015, there was a Supreme Court Public Defender Task Force, and the data was terrible in Mississippi, as you can imagine, but they agreed through this task force to take this basic recommendation to add a simple checkbox to every single notice of criminal disposition form for juvenile and criminal cases. What was the type of counsel? Just indicate in a checkbox. And they managed to do that. Now they were having to transfer into an electronic case tracking system in the courts, and I'm hoping that they carried that forward. But I would really actually love to take the pulse of all states to say, how many of you actually do that most basic thing? And if they don't do it in your state, to really encourage that as the most basic, you have to be able to understand what percentage of the overall workload is being handled by appointed counsel or not, or not. So that's one thing that I think we just all have to keep in mind if that's not already done.
Yeah, I really appreciate that. Christopher Boyle, you have a hand up.
Yeah, we have Legal Server in our office. We spent about 2 years customizing all of the different forms on what we use, but we spent a lot of time figuring out workflows. So our position, we went digital, so we don't have any paper anymore. We went completely, we use SharePoint integration with our case management system for all of the paperwork on our cases, because there's been a new discovery law in New York State that we get just tremendous amounts of data that's sent through a portal. So what we did first was we kind of did workflow charts that what we're hoping, as we've been rolling it out over the last year, is that we are operating more as a doctor's office. So everybody who kind of touches the case does a case note, looks at the case. So if the social worker does something, they take the case and do something with it, or the investigator does something with it, our paralegals do something with it. We've built in a bunch of forms for data that we're looking for that have to do with specific hearings and trials and bail reviews and writs and different things like that. So we have a bunch of admin that still do intake forms, because we have our criminal court folder where we pick up cases for arraignments, acts as a checklist. So we use that as the intake. So the initial intake form has a tremendous amount of data on it, and we split that form up between our admin, so it's not overwhelming to the lawyers. The admin does it and then the lawyers do it. The fact that we took paper away from the lawyers, we're trying to force them to do all of their updates, all of their informational tasks through the case management system. We gave everybody iPads and pens on iPads if they wanted to write and convert writing. We gave them laptops so they could work from home to do this kind of stuff, because the old case management system was not a case management system that was accessible through the web. You had to have it and come into the office to your desktop. So we used the COVID pandemic as an opportunity to go fully digital and to push towards the new case management system. So we have high hopes for the amount of data that we have been collecting. We certainly don't ask to collect data that we don't think that we could use for other purposes. Obviously, there's data we're required to take. There's data that I think is going to be important in the next year or two, depending upon what our funders are going to do. And then there's data that we think is important for discriminatory purposes and things like that we want to show the press when we get press inquiries and stuff. So far, I think it's been working out fairly well.
Yeah, fantastic. I love to hear that. So I actually, as part of my work as an independent contractor, I also work on deployments and setup for Legal Server for offices like the kind of thing you're describing, if possible to, if possible, set up an intake process that is entirely inside of Legal Server, right? That just collects all that information as part of one of those processes. As it relates to this conversation, the challenge that we would have often is I would work with a provider. I worked with, 2 different providers in Minnesota, interestingly, on Legal Server stuff. And there were places where we're like, oh yes. So we previously set up this kind of a sort of data collection setup for a specific statewide grant that they were getting or whatever, right? But then so many other aspects of the data collection, they would say, we have these unique needs that are different from this other Minnesota provider who's doing the same kinds of work. And this was in a civil legal aid context, but this happens in the public defense context too. I think that a lot of people have harped on this, and I think it's really something that's worth thinking about is in a state that is a home rule type state, if people can get together, this is related to what Paul was saying, can really get together and think about, okay, but what is the standard structure that we can use around the whole state to be thinking about this, even though we don't have to, because we don't have a statewide organization telling us to. What is a structure that we can be thinking about that'll keep this all structured in a way that would make it easier for us to compare to each other, to work with each other, and to report, especially in New York, this work of we need to be able to report the same way, right? We want to be able to report to ILS and provide the information that ILS is asking for in a standardized way. ILS is trying to do a lot of that work, but there are not organizations like ILS in every state. And that's where it maybe will fall to providers in different counties to just meet with each other and brainstorm. It's very challenging because each state's going to have its own kind of way of trying to solve this problem. Yeah. It's really great to hear all these different perspectives. We have about 3 minutes left on this call. there's been a lot of different examples of challenges that we can see in home rule context versus statewide context, and a lot of suggestions on how people might be able to work through it. I don't know if anybody has any final thoughts before we wrap up within the next 3 minutes. I think IDRA can be a great place for people to really start to solve these problems, right? So we just have a very large list with a lot of people on it. And if people are trying to start initiatives to speak with people in their own jurisdiction, in their own state, about how to solve these kinds of problems, the list can be a great way to start those conversations and to learn from each other about this.
Being the final word is very intimidating, I guess.
Yeah.
Like, I have other stuff I would say, but it's all like minutia. So
yeah. Well, then how about I'll just be the final word, and you don't have to be intimidated because I'll just botch it for you. So thanks everybody for being here. As I said, I think IDRA is in a unique position to be able to create these kinds of conversations, to learn from the successes and even just the efforts, even if they haven't been successful in other parts of the country. Another thing that's been very good about this conversation is hearing all the way from the perspective of, let's say, like an ILS or the Indiana Public Defense Commission, all the way down to like individual providers in specific counties trying to figure out, what do I do with my 4 people in my rural county? There are so many different perspectives across that whole swath. And I don't know if there are a lot of places where those come together aside from this community. So I'm very, very happy that so many people could join and share during this conversation. So thank you all again. Thanks again to the Deason Criminal Justice Reform Center as our Southern Methodist University for being our host and for setting up our Zoom room today. Make sure, if you want to learn more about IDRA, if you happen to see this and you're not actually a member, please go to our website, indigentdefenseresearch.org. There's information there on how to join our mailing list and how to follow us on Twitter and all that kind of stuff. So other ways to get involved and stay involved with IDRA if you want to be part of our next conversation. So thank you all very much.
Thanks for moderating, Stephen. It was great.
Yeah. Thanks, everyone.